Good afternoon. Very nice for all of you to join us today. We started a little bit late and I apologize for that. And I think we still have some people joining. But because we have such a lot of important contributions to be made, we're going to make a start. Before I introduce the panel and the topics that we're going to discuss today, just for everybody's information before we start, as is usual with these sorts of webinars, we have placed everybody on mute. There is an opportunity to answer questions, to ask questions and through the Q&A, and we'll do our best to answer questions at the end of everybody's contributions and also through the Q&A function if we're running short of time. There is also a chat function that allows you to put in queries and questions, and insofar as people have resources, we'll circulate those after the webinar. It's also important for everybody to know that this webinar is being recorded, so both by audio and video, and it has been and will be shared on our Facebook page, which increases the ability of people to participate because they can see it at a different time. That does mean, of course, therefore, that it will be on social media. So that's the general introduction. I'm sure that everybody's heard 1,000 times now, but I want to welcome everybody to what is Garden Court's contribution to the Lesbian, Gay, Bisexual and Transgender History Month. And my name is Stephanie Harrison. I'm one of the heads of chambers at Garden Court. We consider it as a chambers to be very important that we participate in this event in order to do what the History Month idea is, which is to record and to celebrate the history of gay rights and related civil rights movements, to celebrate and to recognize the contribution that LGBT people, their culture, their past and present has made to our society to increase the visibility of LGBT individuals, their lives and experiences. It's particularly important to recognize that the origin of the LGBT History Month dates back to 2004. That was the year in which the infamous Section 28 was repealed. For those who don't remember that, but for many it's emblazoned on their memories. In 1988, the government introduced Section 28 of the Local Government Act, which made it effectively prevented local authorities from intentionally promoting homosexuality and promoting teaching in schools of the acceptability of homosexuality. So only in 2004 did that pernicious piece of legislation get repealed. And it's right for no other reason to have some form of celebration and marking at the end of that piece of legislation. It might also be helpful to remember that it was only in 1992 that the World Health Organization declassified same-sex attraction as a mental illness. So when we come to look at history, whilst for many of us 30 years seems a very long time, it's really a contemporary situation where the institutionalized discrimination against lesbian, gay, bisexual and trans people was well and truly live and kicking. However, this webinar is aimed at looking at one area of the work in which the LGBT movement and campaigns have had a very effective role in raising the profile and issue of people suffering from HIV who face immigration problems. And it's particularly gratifying as a barrister at Garden Court, where immigration law is one of our main areas of practice, to be able to bring together individuals who have worked in crossover areas, campaigning both for LGBT rights and also the rights of asylum seekers and migrants. We're going to hear from, I'm very fortunate to do so, from Wesley Gryk, who is an immigration solicitor with deep experience in these areas. And he's going to give us that historical context of how these two issues come together, in particular by looking at the Terence Higgins Trust, because it was that organisation that was at the forefront of bringing cases based on immigration cases, based on individuals seeking asylum and also suffering from HIV and seeking international protection on that basis. And so the coming together of those two things is at the heart of this seminar. Looking at the statistics for those within the United Kingdom who currently are diagnosed with HIV, the recent figures are just over 105,000 people. 41% of those people are gay or bisexual men, but 37% are Black African men and women. And within that group, there's going to be a very significant proportion who have an immigration problem with their status in the United Kingdom. And from where the critical issue that we're going to discuss today, the protection from removal for those who suffer from HIV, and hearing from two perspectives, both from Francis Webber, a former barrister at Garden Court Chambers and activist, is going to talk about the historical legal cases. Then we're going to look at the contemporary position. Zehrah Hasan, a barrister also at Garden Court Chambers, is going to talk about that. And we're also going to hear from Raza Halim, another barrister who's going to focus on the position for those with HIV who find themselves in immigration detention. Lastly, we will be hearing from Leila Zadeh, who's going to give us some information about the campaigning that she's currently involved in, and how we may continue to pursue the work that others have done in this area. Ultimately, we are going to be looking at how and if Article 3 of the Convention does provide the sort of protection from inhuman and degrading treatment that we would hope that it does. We can see when we hear from the case law that what Article 3 has become is not the floor, but the ceiling of protection, and that in many ways the use of Article 3 emptied out compassion from our immigration system in the way in which it treats this particularly highly vulnerable group of migrants and asylum seekers. It also raises critically a pressing issue of our time, which is how do we deal with the unequal access to medical treatment and the fact that we have a situation where here those now who are diagnosed with HIV can expect to have the same life expectancy as anyone else because of the medical advances that have been made. But if you are removed back to a country, many in African countries, your life expectancy will be reduced to 1 year. That kind of global structural discrimination within our system is at the heart of the backdrop to these important legal and campaigning issues. And so I hope that at the end of this discussion with these contributions, we will see how we can take these campaigns forward and continue to have that context in our legal work. So first then, we're very fortunate, as I've said, to have Wesley Gryk speaking first. He's going to outline and to give us the context and background to these topics. And I'm sure he's going to put some of his experiences in the context of what many people may be viewing at the moment, which is Russell T. Davies' drama, which is bringing to life those that period in the 1980s. So Wesley.
Thank you very much, Stephanie. It's quite nice to become a gay man of a certain age, because come February, you know that you have a pretty good chance of getting a gig as a specimen gay man of olden days. And so this year in particular, I'm very glad to be able to speak in this particular context, because I've been watching the Russell T. Davies programs. Well, indeed, I've been trying to savor it, one episode a week, but I felt I had to watch the whole thing this afternoon so in case there's anything relevant to what we're discussing today. And it's such a moving portrayal of the 1980s, and also, I would say, a very accurate one. It doesn't cover everything, but all of the sad points, all of the emotional points, the heartening points are extremely accurate. And I'm able to say that firsthand since I arrived in this country in 1980, 1 year before the program begins in 1981. And just as Mrs. Thatcher had come into power, and just as the AIDS epidemic was beginning in the US, and I think the first case in the UK was in 1981, with a second case late 1981, and it went on from there. While I spent most of my recent career as an immigration lawyer, I'm going to leave a lot of the immigration law, the immigration practice, to the barristers who follow, who've been doing it, because I think, from my point of view, the subject matter of the seminar today needs a bit of justification. I don't think it's good enough to say that because gay men had HIV and Africans had HIV, issues with respect to African immigration and HIV are a relevant subject matter for this particular historical month. But in reality, I think they are, because while in some ways, as I'm going to outline, the pandemic then was a horrific and terribly sad one, and horrific and sad in different ways than the present one, but in some ways, far more shocking to those who were the victims of it. At the same time, it occurred at a time when the sort of stock of minority groups affected were at their lowest. We had Mrs. Thatcher saying there's no such thing as society, being absolutely against the idea of gay relationships being recognized in any way. Then you had this horrible so-called gay plague, as it was called at the beginning, occurring. And you would think that in the end would just be the straw that broke the camel's back for the communities involved. But what I like to think, and the lesson I'd like to take out of it, is that as a result of the horrors of the pandemic, we proved Mrs. Thatcher wrong to a certain extent, and proved, yes, there is society. And when it emerged that the groups most affected by the pandemic in the UK, namely gay men, drug users, Africans, and hemophiliacs infected by products imported from the US, were largely minority groups who were simply not highly represented in the halls of power, and not much was being done for them. To a certain extent, the situation they found themselves in, while it could have been remedied, could have been seen by them as hopeless, instead they built upon it and created a structure not only to help one another, but also to bring in other worthy people who believed in the concept of society, and the concept that when a pandemic strikes, whoever its victims are, we care for them. And everyone came out of it stronger, but at horrific costs. And the costs were very high, because if you compare it with the present pandemic, there were a lot of things quite different. First of all, the whole thing emerged in slow motion, because the groups affected were unpopular groups, and most ordinary, normal people didn't think they were likely to be affected. There was no particular pressure on the government do much. I think it's quite astounding when you think that the problem began emerging in the UK in 1980, 81, and the commercials with the boulders and the crashing waves didn't come out in 1986. In fact, it was 1987. And the famous handshake by Princess Diana, which, while it seems a bit corny, was a real breakthrough moment where she actually was prepared to touch a person with HIV, also didn't take place until 6 years later. And not a lot was being done by the government during that period. And pretty soon, the groups being affected realized that if things were going to get done, they had to mobilize themselves. And here's where I think the LGBTQ plus month connection comes in that as the group, the most affected, the largest group affected in the UK, and the group which had relatively more resources in terms of money and influence in the various professions, gay men played an important role in it. LGBTQ plus community generally did, and like-minded people of every group became involved, including the liberal lawyers, barristers, and they brought about change by chipping away the problems one by one. And that happened in the legal profession. That's what I'll concentrate on, but it was happening in other professions as well. To take just a couple of examples, one thing highlighted in the program was that it was almost impossible to get information in the UK about the progress of the pandemic, what was causing it, what to do to avoid it. I should pay tribute to one man in particular, a man who in fact worked for our firm towards the end of his life, the late Michael Mason. He was a journalist who set up a newspaper called Capital Gay in, I believe it was actually 1980. In the program, it was called London Gay. But that was the only solid source of information and statistics in the UK about what was happening in the UK relating to HIV. I remember there's a little box in the front page of the newspaper saying how many deaths there had been so far in the HIV epidemic. And in fact, the figure was in single figures when I began to read the paper in 1981, and it was soon up into the hundreds and into the thousands. And all the latest medical theories from the US were published there. I remember taking hope in the concept that said, well, only 1 of 5 people who get infected are likely to die, which didn't prove to be true at all. And ideas about how transmission was carried out. The first time I remember the mainstream press carrying out something equally informative was in 1983. There was a program called Killer in the Village done by the BBC, where a BBC reporter in very posh upper-class tones at the time went into Greenwich Village and was reporting the spread of Kaposi sarcoma and the various illnesses that were going on. But until then, it was Michael Mason's newspaper which was informing people, and I feel certain that he probably saved thousands, if not tens or hundreds of thousands of lives as a result, people realizing they had to be safe. But not only were things going very slowly, another problem was the fact that for many members of the minority groups, particularly drug users and gay men, they simply didn't want to be unveiled as somebody who was a drug user or a gay person, because many people were still closeted then, and a decision to come out was made only after a lot of careful thought, because if you were in some profession and you appeared in the news of the world, you risked losing your job. And one of the phenomena early on in the pandemic was that men who were initially diagnosed as HIV, they showed this in the program, and I know an actual case, basically took a decision to die. They were they got their first AIDS-defining illness, and these are a series of illnesses you get, any one of which could kill you, but usually you had a horrific series of them before you died. You might wake up blind one day, or have a rare form of pneumonia another day, or have a very rare form of skin cancer, which only elderly Mediterranean men get another time. Sooner or later you would die. But one of my close friends, I'm sure, who wasn't out at work, he was a civil servant, got his first AIDS diagnosis illness. He had no idea he was HIV positive, and he in fact never left hospital. And in his workplace, it was announced that he had died. No explanation was given. A bit like the scene in the program where the man working in the tailor shop in Savoy Row disappears from the workplace. No explanation is given. There's also prejudice against the groups, and it's assumed that if you're a member of a group, you might well be HIV positive. I know that I had minor surgery in 1983, and my then partner came and said, "Did you know that there's a sign on your door saying risk of AIDS? Be careful before entering." And it was not because I had any diagnosis of AIDS. It was because the admitting doctor knew that I was HIV positive. And things like that were happening all around. And finally, very quickly, gay men in particular realized they needed to do something. An important breakthrough happened in early 1982 when I think it was the third victim of HIV who died in the UK. Terence Higgins died, and two of his gay friends decided they were going to do something. They set up the Terence Higgins Trust, and it was an organization which, one by one, tried to solve the problems facing all the groups, Africans, drug users, hemophiliacs, and gay men equally. And they did some very practical things, such as setting up a buddy system so that anyone who was HIV positive and facing a very real prognosis of death, not knowing when the death was going to occur, next week or next year or in 10 years, they were set up with a buddy who would see them, help them do chores, and basically buck up their spirits. By the middle of 1985, a legal group had been founded, and lots of top lawyers from many different areas joined it and were getting involved in different issues. To mention too that I was very involved at the time. I had quite a lot of time on my hands because the Law Society in its wisdom decided that I should be treated like someone who didn't have a law degree and had to do Law Society finals and CPE exam and articles. So I joined the group, and two projects I was proudest to be involved in was one with respect to insurance premiums. And insurance brokers took the decision that they were going to raise life insurance premiums extremely for gay men because of the risk of AIDS, and wait for it because they were by definition promiscuous. Bisexuals couldn't get life insurance because they had at least two partners, which is a rather absurd decision. But what we did is we lobbied for them to change their policies. They weren't very willing, and it wasn't that easy to change the law. But the main thing which we did was to advise gay men seeking mortgages that they were very unlikely to need an endowment mortgage, which turned out to be a bad investment in any event. And endowment mortgages had high insurance premiums connected to them, but extremely high insurance premiums if you happened to be gay, even if you weren't HIV positive. And so we spent hundreds of hours giving workshops to people, telling them to avoid that pitfall. Another project which a colleague of mine in the group set up, Robin Dormer, who was then working for the Department of Health, was to introduce to the UK the notion of living wills, what are now called advance directives. There is no concept that popular in the UK then, and it wasn't a concept which was clear in law then, as it is now with advance directives. But from 1990 to 1992, a small working group of us led by Robin and also guided by the Medical Ethics Department of King's College, worked on producing the first living will, which won in due course a plain English award and was put in all the important form books as the guiding form book. And one of the ironies of that, while this was something very much wanted by people affected by AIDS, because they might, in one illness, become prematurely senile and not be able to take medical decisions on their own behalf, they wanted to set them down in writing and to designate someone they wanted, a partner perhaps, rather than a parent, to take the decision what was going to happen if they were unable to take decisions themselves because they didn't have the mental capability. And oddly, when we began to promote that, the take-up of it was very high in our own client groups, but it was far higher from little ladies and gents from the West Country who, when we would appear on the radio talking about it, hundreds of requests would come in. So I think Terence Higgins Trust and everyone involved in it, gay, straight, anywhere on the spectrum, were busy doing their best to try to contradict Mrs. Thatcher when she said there was no society, or the relationships which we were building up were, she said in the Clause 28 debates, pretend families. With respect to immigration, I'm going to leave it to Fran because she did a key case for them, except for one sort of cynical comment that I can make about how the government tried to save themselves a little bit of money with respect to HIV treatment. The big campaign, which I was involved in during that period with respect to lesbian and gay immigration, was being carried out by an organization which we formed, which Leila is heading today. And at that time, we were working for the recognition of same-sex relationships in the context of immigration law. And we didn't really make a breakthrough or get a change in the law until the Labour government came into power in 1997. But in the early 1990s, suddenly there's a little shift in mood in the government, and the then conservative government allowed a couple of cases of minor celebrities, but they allowed a number of cases where we made the argument, look, the foreign partner is healthy, his British partner has an AIDS diagnosis or is quite ill with HIV. If you let the foreign partner stay, it will save money to the health service and the Department of Social Services. And sure enough, the government, for its own advantage, and cynically allowed those few people to stay, whereas by that time, thousands of other people had applications pending who didn't get such a result. But it was a little minor victory for morality and justice. I think what I would say is that things were very, very horrific at the time for people who were going through it. You didn't know when you were going to die, but you were pretty sure you were going to die. While there were tests that were developed very quickly, because the onset of AIDS often came, 5 or 6 or 10 years after you became infected, most people just didn't want to know. There was no benefit in getting tested and finding out you had it because there was no treatment. And so that was extremely isolating, living in fear. I feel I probably survived because I left New York in 1978 and went to Hong Kong and sort of missed out those 2 very infectious years in New York. But I wasn't sure that I didn't get it from New York in the mid-70s. So people were very afraid, but they also formed between themselves very intimate bonds, as you see in the program, for those of you who've watched it. But they also formed strong bonds as communities. And while these were tough times, I feel that the LGBTQ plus community, combined with liberals of every sexual ilk, really put a thumb in the face of Mrs. Thatcher and showed, you aren't going to do anything about this, but we will continue to fight until you do. And because of the hard work of equally decent doctors and nurses. By 1997, people whose deathbed you'd been to in 1996 were thriving and are still thriving today. I brought along, just to put on the screen for my last contribution, one of my most treasured possessions. I bought it as a 70th birthday present to myself a year ago, and it's a photograph, and it's a photograph of two artists. No, that's not it. No, the black and white photograph of a man in bed. It's David Arnovich, who is quite a well-known AIDS activist and artist who lived in New York, and it's taken a couple of years before he died, and it's taken by his lover, Peter Huyar, a Ukrainian-American photographer trained by Richard Avedon, also a very good one, and taken by Mr. Huyar about a year before he died. And you can see in the stare of David into Peter's eyes, if we find the right picture, the kind of intense bonds which were formed between couples, between individuals, between social groups like those featured in the program. Although they came up against lots of opposition from the law, from families, but in the end, oh yeah, there you go. I don't think on my little phone, I can't see it very well, but it's a very beautiful, tender photograph of David looking into the eyes of Peter, each of them knowing that they were likely to be dead within a year or three, as indeed they were. But for me, it's a good epitome of what that period meant for our communities.
Thank you.
You're welcome.
I think Wesley touched in his talk on some success that came in 1997, and I think before we move on to Francis, I think it's really important to record and to recognise just how significant that work was that Wesley and other lawyers did, in particular Matthew Davis at Wilson and Co. to persuade the government through tenacious campaigning and through excellent lawyering that they must recognise same-sex couples. That was 1997. It wasn't until 2004 that became in the statute in terms of civil partnerships. So it was a radical step, and it would not have occurred without the incredible skill, commitment, and compassion and humanity that Wesley was a leading force in that movement, and we have to pay tribute to you for that. So we are going to move on to looking at the law in the context, in particular, of immigration law directly. And as I indicated at the outset, that it's we're going to move first to hear from Frances Weber. Not only is Frances a barrister at Garden Court for many years, she was probably busier once she retired in 2008, similar to what Tony Benn said about retirement, because she continued to teach at Warwick and Birkbeck. She wrote an excellent book that tells us a lot about some of the things that Wesley said about the way in which campaigns make connections across communities and within communities of borderline justice. And if you've never read it, I recommend it, published in 2012. She continues to work tirelessly and effectively as a volunteer at the Institute of Race Relations, writing on refugee, migration and human rights issues. The one thing she won't be sad about not writing is MacDonald, which she did co-edit in the 5th and 6th edition. It's currently in its 10th edition, sadly without its founder and editor, Ian MacDonald, but still it continues, and it wouldn't be the book that it is today without Frances's contribution. So Fran, over to you.
Thanks, Steph. That's a very nice introduction. Okay, so the law. Oh my God, I haven't thought about the law for well, a long time. Right. So N, I'm talking about N. I was instructed by the Terence Higgins Trust in the Court of Appeal, and then in the House of Lords, as it then was called, the Judicial Committee of the House of Lords, the precursor of the Supreme Court, with Nick Blake. So Nick, of course, Nick Blake had been the advocate in the case of D v UK in Strasbourg in 1996, I think, which was the case that we all jumped up and down about and said yay, or the equivalent in those days. I don't think we said yay, which said that Article 3 was engaged by expulsion exceptionally if the applicant's removal would sufficiently exacerbate the suffering flowing from a naturally occurring illness. So D, you probably all know this, D was, I think he was arrested on arrival for the attempt to import a lot of drugs. So he became very ill with HIV/AIDS while he was in prison. And the case went to the European Court of Human Rights just as highly active antiretroviral therapy was beginning. But I think that the Strasbourg judges sort of didn't know about it or weren't aware of it, so that D was presented as a case where the man was going to die, and the question was whether he should die in the gutter, basically in St. Lucia, on deportation, or whether he should die in relative comfort, surrounded by people whom he knew and who'd been looking after him in the UK. So that was really the issue, or at least that was how it was presented then later when N came along. So, but certainly he was suffering from a terminal illness, and as far as the court was concerned in D, it wasn't treatable, so he was going to die. So that was an amazing case. It was the first case where the court said that it would look at a claim under Article 3 where the source of the risk of prescribed treatment in the receiving country stems from factors which cannot engage either directly or indirectly the responsibility of the public authorities of that country. So in other words, they're not doing anything to him. They're not failing to prevent non-state agents from doing stuff to him, and they are not themselves in breach of Article 3. But it's the expulsion which is inhuman, basically, because it subjects somebody to intense suffering and to a much shortened life expectancy. So the European Court of Human Rights, having done that, the Home Office then did formulate in 1998, I think it was, instructions on the grant of exceptional leave to remain, which was a much more generous status, I think, than humanitarian leave, but I can be corrected on that. Basically, they formulated it where there is credible medical evidence that return due to the medical facilities in the country concerned would reduce the applicant's life expectancy and subject him to acute physical and mental suffering in circumstances where the UK can be regarded as having assumed responsibility for his care. So that was the condition, or the threshold, which was formulated following the case of D. Meanwhile, no, not meanwhile, I think in 1999, the process for people, for overstayers, including refused asylum seekers, changed from deportation, against which there was a full right of appeal, which included looking at all the circumstances of somebody's life in the UK and all the circumstances of what they would return to, including compassionate circumstances. That right of appeal was removed from overstayers by the 1999 Act. But then overstayers they had a human rights appeal after October 2000. And that's, I think, what Steph was talking about when she said that Article 3 became the ceiling rather than the floor, and that the courts, or certainly the immigration appellate authorities, weren't looking at in the round compassionate circumstances in the round, which they had done before. Anyway, so that was the sort of background. So N was a survivor of rape by first the Lord's Resistance Army, then by the security forces of Uganda. And she came claiming asylum in 1998. She was 23. She was incredibly ill. She was admitted to hospital the next day. She had TB, she had Kaposi's sarcoma, and her CD4 count was 10. So she was very, very ill. She was put on antiretrovirals and her condition was stabilized. Meanwhile, her asylum claim, based on what she had suffered and what she had a reasonable expectation of going back to, was rejected. The appeal on asylum grounds was dismissed on the basis that these rapes were just done by rogue elements, they called them. But the adjudicator allowed her appeal under Article 3 with reference to the Home Office policy. And the tribunal, as was its wont, allowed the Home Office appeal, but on a mistaken basis. The tribunal said, oh, there's treatment is available in Uganda, so she'll be perfectly okay, she'll be able to get treatment. In fact, this huge gap had opened up, just the same really as the gap that's opening up now in terms of COVID vaccines. So in the late 90s, early 2000s, HIV patients, HIV/AIDS patients in the UK had a reasonable expectation of a normal life expectancy on HIV, on antiretrovirals, but they cost around £10,000 per annum, per person per annum. And the big pharma, the big pharmaceutical companies were were taking to court. I think they took a case to the World Trade Organization against India and Brazil, which were manufacturing generic drugs generic antiretrovirals and were sending them to other countries. So so the big pharmaceutical companies who were selling the drugs at £10,000 per person per year were suing for breach of intellectual property rights. And so there was a global campaign which did eventually shame these companies into withdrawing the legal proceedings, but and also forced the prices down, the prices charged by the big companies, but it was still unaffordable. And so in most African, I think probably all African countries, the vast majority of people simply could not afford the drugs that were needed, and the medical infrastructure wasn't there. So it was ridiculous to suggest that medical treatment was available in any real sense, and we were absolutely outraged. So I was instructed by Terence Higgins Trust to intervene in the Court of Appeal. And so the Court of Appeal accepted that the tribunal had made a mistake in saying that treatment was available. They accepted that treatment was not available in any real sense to this woman. They accepted the medical evidence that her position would be similar to having a life support machine switched off, which is the medical evidence was saying that if she was forced to return to Uganda, her lifespan would be dramatically shortened from potentially decades of high quality life to almost certainly less than 2 years. That was all accepted by the Court of Appeal, but by a majority of 2-1, they ruled against her, saying that the case of D did not mean that people could rock up in the United Kingdom and get free medical treatment for life, basically. So we went to the House of Lords, and again, as I say, Terence Higgins Trust instructed, and it was shocking, actually. I mean, it was shocking that the lengths to which the court was prepared to go and the dishonesty behind the judgments, the way that they were trying to wriggle out of the plain and simple, obvious truth that this person was going to be exposed to the most intense suffering, shortened life expectancy, that was not enough to engage Article 3. And reading through the judgments again recently, preparing for this seminar, maybe I concluded that, well, perhaps they were in a very difficult situation. I can see that the judges were in a difficult situation. They remind me of sort of reluctant border guards, that they don't want to say no, but they've got no choice because they can't open the floodgates. By the time that N was in the House of Lords, in fact, the European Court of Human Rights had backtracked hugely from D. So there'd been quite a few cases. There was Carrara in Finland, also in 1998, MM in Switzerland, Tatetevi Switzerland, SCC in Sweden, Ben Said, which was an expulsion of a schizophrenic man to Algeria from the UK, where there was a risk of severe deterioration and self-harm, possibly suicide, because of the inaccessibility of antipsychotic drugs. Henau in Netherlands, Dangoya and Sweden, Amegning and Netherlands. So there were a whole load of cases where the European Court for Human Rights had sort of backtracked and said, oh no, these cases, the person isn't ill enough. And to be fair, some of them were indistinguishable from N, because they were cases where somebody had been ill, had presented with AIDS-defining illnesses, but had been stabilized with antiretroviral medication. And so they weren't ill at the point where their removal was being considered. The fact that they would become very ill very quickly, the court simply refused to look at. And in fact, it was quite interesting, because in the House of Lords, you can see the judges struggling with these decisions and trying to make sense of them. And Lord Nichols actually said, why is it unacceptable to expel a person whose illness is irreversible and whose death is near, but acceptable to expel a person whose illness is under control, but whose death will occur once treatment ceases, as may well happen on deportation? So Lord Nichols put that question in his judgment, and he said, these questions are not capable of satisfactory humanitarian answers. The humanitarian considerations in the present case are of a very high order. So then what he decided, and what the other law lords decided, was that you can't decide this Article 3 case on the basis of humanitarian considerations. No, it's nothing to do with that. It's to do with you cannot, it's recognizing that Article 3 does not require contracting states to undertake the obligation of providing aliens indefinitely. I know Steph hates that word, aliens, indefinitely with medical treatment lacking in their home countries. So they've managed to turn it into a positive obligation to provide all these people who are flocking to the country with medical treatment for life, basically. And so it comes down to a matter of resources. So that was really what the conclusion, that was how they got there. And when the case went to the Strasbourg Court very gratefully more or less adopted the reasoning of the House of Lords, because the Strasbourg Court, hadn't formulated any test really since D, but obviously they'd rejected all these cases. A lot of them they'd said they were manifestly unfounded. And anyway, so they basically said that Article 3 does not place an obligation on a contracting state to alleviate the disparities in treatment because of the advances in medical science, the disparities in medical treatment. Article 3 does not place an obligation to alleviate such disparities through the provision of free and unlimited healthcare to all aliens without a right to stay in its jurisdiction. I should have said, by the way, that during the hearing, I think the only question that we were asked as Terence Higgins Trust was how many African patients we had. And we found the number. It was sort of somewhere in the low thousands. But the Home Office, I can't remember even who was representing the Home Office, but they sort of jumped up and said, sort of, my lord, there are 25 million HIV AIDS sufferers in Africa. So you know, you suddenly got this picture of 25 million people sort of, if they allowed this appeal, there would be 25 million people coming to this country to get free treatment for life. So it was shaming. It was dreadful. And there was a very, very good dissenting judgment in Strasbourg by 3 judges. The House of Lords decision was unanimous, but at Strasbourg, the dissenting judgment was very, very powerful. It accused the majority of adding worrying policy considerations, reintroducing the heresy of balance or proportionality into Article 3 by suggesting that the enjoyment of rights guaranteed by the Convention can be restricted on the basis of policy considerations such as budgetary constraints. And so they were, the dissenting minority was very angry at the implicit acceptance by the majority that finding a breach of Article 3 in the present case would open up the floodgates to medical immigration and make Europe vulnerable to becoming the sick bay of the world. So very powerful dissent. 3 judges dissented. And they, I think, have now been vindicated. But obviously that's something for the next speaker to talk about. So as far as my contribution was concerned, I'm afraid my contribution was to the low point of the debate in terms of the law. I think that's it from me.
Yes, thank you very much, Frances. And Frances is right. Whenever you hear the word alien used, you always know that the outcome is going to be one that is based in inhumanity and contrary to justice. We are going to hear now from Zehrah Hasan, who is going to follow on the story with what has recently happened with subsequent case law and the domestic case of AM Zimbabwe. As I said to you at the beginning, Zehrah is a barrister at Garden Court. She's a new tenant who came to us in October 2020. We're very fortunate to have her. She's got a wide-ranging experience of working in a number of different organisations in Liberty, Southall Black Sisters and the London Black Women's Project. And within that work that she has done, she has a particular focus on policy work relating to LGBTQ and other rights, in particular relating to trans rights and advocating for reform, for example, on the Gender Recognition Act. We are going to get her insight from both the legal perspective, but also having been working for a very long time in the policy area on these topics. Thank you, Zehrah.
Thank you so much, Stephanie. So yes, following on from Frances's very comprehensive outline of the history, the case law in respect to this, I'm going to talk about AM Zimbabwe, which I'm sure lots of you are familiar with. And so the UK Supreme Court gave judgment on AM Zimbabwe on the 29th of April last year. And it's a vital case which reformulates essentially the construction of medical grounds in appeals involving Article 3. And there are 2 main aspects of AM Zimbabwe I want to consider. The first is how the medical threshold that has been identified in AM Zimbabwe applies to LGBT clients who are HIV positive or have AIDS. And the second is the guidance that the Supreme Court gave on the evidence that's required to demonstrate that a removal in this kind of context would breach Article 3. So in relation to how the case applies to clients with HIV or AIDS, I'll just firstly set out what AM Zimbabwe found. And it is significant because it lowered the previously high stringent threshold in medical cases that Frances set out in N of one of near or imminent death to one where the appellant has to show that their removal from the UK would lead to a significant reduction in life expectancy. And this essentially mirrored the Grand Chamber of the European Court of Human Rights' judgment in Papashvili and Belgium from 2017, which found that the test in Article 3 medical cases is not, as N said, restricted to a person at imminent risk of dying, but is about cases where there is a real risk on account of the absence of appropriate treatment in the receiving country, or the lack of access to such treatment, or being exposed to a serious, rapid and irreversible decline in their state of health, resulting in intense suffering or to a significant reduction in life expectancy. And the Supreme Court considers the meaning of the significant reduction in life expectancy and emphasizes the importance of the adjective taking different colors in different contexts. And so the fact that the UK Supreme Court took this approach in AM is further significant in the context of LGBTQ plus asylum seekers with HIV and AIDS, because AM was HIV positive himself. And in that case, he asserted he'd be unable to access medication that he's dependent on to prevent his condition from developing into AIDS in Zimbabwe. So in terms of the background of AM's condition, he was diagnosed as HIV positive in 2003. And in 2011, his HIV diagnosis gave rise to concern as his CD4 blood count began to fall. In 2012, he'd undertaken antiretroviral therapy with a drug that had given rise to very intolerable side effects, which included vomiting, stomach cramps, dizziness, and night sweats. The clinic then provided him with Eviplera, which is another antiretroviral medication. And this enabled his CD4 blood count to increase and his HIV viral load to become undetectable. And so this treatment clearly needed to continue. And in Zimbabwe, whilst there was a range of antiretroviral medication available, Epiplera was not, and that was the only one that was working for him. And so without access to this medication, his CD4 blood count would fall again, leaving him prey to infections, which, if left untreated, would lead to his death. Now, it's important to note that in respect of AM's particular situation, the Supreme Court decided not to address the argument presented by the appellant, that the medical reports in his case were sufficient to cross the Article 3 threshold, mainly because they had been submitted as part of his Article 8 claim and because they were more than 5 years old by the time of the Supreme Court decision. So AM's case on the individual Article 3 basis was remitted to the upper tribunal to consider up-to-date evidence on his HIV status, but of course to be properly directed by the Papashvili substantive and procedural requirements. However, the key aspect stemming from AM in relation to the medical threshold is assessing A, the absence of appropriate treatment, and B, the lack of access to such treatment in the reformulated medical threshold test. And for LGBTQ plus migrants who are HIV positive, it's even more significant to consider the availability and accessibility of treatment or medication in the country of removal, in light of their position as people who may face further health inequalities or discrimination on account of being queer and or trans. And it's further important, in my view, to consider multiple barriers that they may face to accessing treatment, for instance, additionally on account of race. So for LGBTQ plus people living with HIV on a global scale, they frequently experience abuse and discrimination within healthcare settings, including coercive treatment practices, a lack of informed consent, stigma, discrimination, physical abuse at the hands of healthcare providers, and for some forced and coerced sterilization or abortion. And so whilst the right to health is protected by certain international instruments, including Article 12 of the International Covenant on Economic, Social and Cultural Rights, which is acceded to by many countries, this doesn't mean that the reality and the ability to access healthcare is going to be free from discrimination in the places that many of our clients are facing removal to. And I'm actually dealing with the LGBT asylum appeal tomorrow and looking at the background evidence for that case. In Tanzania, for instance, the persecution of LGBTQ plus people has intensified since 2016 due to widespread political repression. And before 2016, there was scope for LGBTQ plus Tanzanians to access HIV prevention and treatment services. However, since 2016, the Ministry of Health there has banned NGOs from conducting any outreach activities about HIV prevention with men who have sex with men, and they've closed centres where testing has been available to LGBTQ plus Tanzanians. So this has, of course, prompted fears that HIV positive Tanzanians will be unable to access essential antiretroviral drugs, and more broadly constitutes a deprivation of the right to health for the LGBTQ plus population. And therefore, for LGBTQ plus asylum seekers and migrants, the accessibility of treatment is not just about HIV or AIDS services in the country, but how safe they are and available they are for queer and trans people in light of the widespread denial of these services to these communities. And so it's really crucial to consider the specific country context regarding LGBTQ plus rights extremely carefully alongside the medical circumstances of the individual appellant. It's also important to think about socioeconomic factors, for example, the reliance on private healthcare in some countries, and how this means services would not be practically available to some LGBTQ plus people. For example, being queer can often intersect with economic disadvantage in certain countries due to people having to leave their families if they have been disowned or rejected on account of revealing their sexuality or gender identity. And they also may face discrimination in accessing employment. And so that means they'd be unable to access private healthcare. And there's, of course, further intersectionality in respect of discrimination in healthcare systems where racism may be an issue. And so it's absolutely clear that it's really crucial to think about what accessibility and availability of medical treatment really means for LGBTQ plus individuals. And so my second point is just looking at how we can demonstrate and meet this evidential threshold. And the UK Supreme Court did give guidance in AM Zimbabwe regarding the evidence an appellant must adduce to establish a violation of Article 3. In essence, the evidence must be capable of demonstrating substantial grounds for a very exceptional case because of a real risk of subjection to inhuman treatment. And so the court stated in no unclear terms that the threshold places an obligation on the applicant to raise a prima facie case of potential infringement of Article 3, meaning that if it were not challenged or countered, it would establish the infringement. And so, as Stephanie alluded to, the threshold does still remain extremely high. However, working within this context, in terms of the evidence we should be adducing for individuals, we have to think about the country evidence on accessibility and availability of treatment across the region, as well as expert medical evidence, which goes into the detail of a person's individual treatment needs. So, for example, considering the ineffectiveness of certain antiretroviral methods for some people, as it was in AM's individual case, is vital. And further, getting comprehensive medical evidence of treatment options or current procedures the person is undergoing in the UK for HIV or AIDS, and why this cannot continue to the same or an appropriate standard in the country of removal will be particularly compelling. So we need extremely detailed country expert reports and medical reports that look at all of the factors in the round. There may also be a way to assess ways in which the stability and necessity of HIV treatment also impacts other health issues, particularly mental health concerns. So it's important to think about medical needs holistically and draw all of these factors in together. Now, the other thing that AM makes clear with regards to the procedural requirements of Article 3 and following Papashvili, AM also states that it's for the returning state to dispel any doubts raised, meaning serious doubts, by the evidence adduced in support of any application under Article 3. And the returning state has to verify this on a case-by-case basis, whether the care generally available in the receiving state it was in practice sufficient to prevent the applicant's exposure to treatment contrary to Article 3. They had to consider the accessibility of the treatment to the particular applicant, including by reference to its costs and to its geographical location, and examine any relevant information, including whether the returning state had to obtain individual assurance from the receiving state that appropriate treatment would be available. And the UK Supreme Court endorses this approach from Papashvili in its judgment and clarifies that while it is for the appellant to adduce evidence of their medical condition, current treatment, suitability of other treatment, the effect of it, etc., the returning state is better able to collect evidence about the availability and accessibility of suitable treatment in the receiving state. So it's important not to forget these procedural requirements as well in advancing your case, and how you can put some onus on the Home Office to disprove any of the assertions you're making in respect of the availability of treatment, particularly where there are concerns around discrimination for LGBTQ plus people. So in summary, AM is extremely helpful and instructive when it comes to LGBTQ plus asylum seekers and migrants with HIV. But ultimately, the onus still falls on representatives to ensure that the evidence presented in appeals concerning Article 3 is robust, comprehensive and nuanced with regards to the specific issues LGBTQ plus communities face when trying to access life-saving treatment. So that's what I wanted to say, and looking forward to any questions.
Thank you, Zehrah. That's a fantastic elucidation of that case and how we might put it into practice to make the best use that we can. Certainly before AM Zimbabwe, I was looked at a number of cases in the Court of Appeal where there was a HIV issue and where focus had shifted to the impact on children because of the difficulties of winning for the person who has the illness. Focus switched to the impact of the children. I actually saw a case where the tribunal had upheld a decision that it was acceptable to remove the two children with their parent, even though it would mean that the parent, who is a mother, was going to probably die within 12 months. And then it would be then open to them to make an application for the child to return. So that was actually a decision made by and endorsed by the upper tribunal. So it shows you how that framework can extend inhumanity beyond what anyone could realistically contemplate could be endorsed. And so let's hope at least, ultimately the Home Office did concede that case even before AM Zimbabwe, but only at the point at which it got to the Court of Appeal. But let's hope there's no more cases going through the system like that. One other area that is of concern, we've seen the interrelationship between asylum claims and often as a consequence of ill treatment, people suffering from HIV. We're also then going to now look at the multiple ways in which people can be disadvantaged when they're in detention who have a diagnosis of HIV. And we're very fortunate that Raza Halim, who's a barrister at Garden Court Chambers, who's going to talk to us about a case that he's been involved in that covers that topic. He does specialise in detention cases as part of his public law practice, emphasising refugee law and human rights. And he also has a longer background in working with NGOs, advising on strategic challenges, and in particular working for bail for immigration detainees. So thanks very much, Raza, for your contribution.
Thanks, Steph. And I think the point about my contribution is really to demonstrate, by way of the case I'm acting in, that the fight pioneered by people like Fran and Wes continues, and Steph, I should say as well, and that one of the front lines of the battle that continues to take place, as our case shows, is in the shadowlands of the immigration detention estate, and how 40 years on, the state's understanding of the ABC of how having HIV requires to be treated, and the safeguards required when those most vulnerable people are in their custody, remains shockingly bad and at worst potentially fatal. So the example of this case also demonstrates why more than ever collective action, working hand in hand with advocacy groups and NGOs and others interested in the rights and proper treatment of those living with HIV is important now more than ever. Now, our case is about the absence of any policy framework making provision for the critical needs of those with HIV who are dependent on antiretroviral medication in the immigration detention context. What I'm hoping not to do is to do what many barristers like to do, is embark upon a vanity project describing to you why my case is so important. What I'm hoping to do is explain to you why and how this problem and this issue manifests itself now, as I say, in this rather darker area. It's worth noting that my client's detention took place within what is called a short-term holding facility. And this is a kind of subset of the detention network or centers that the Secretary of State runs. And they escape even more scrutiny than the otherwise remote detention centers that people are kept in, and appears consequently to be even less regulated, to the extent that liberty should ever be regulated at all through immigration detention. The very basic facts of my client's case is that he is a national of the DRC and came to the United Kingdom when he was 4. He had his HIV transmitted to him by his parents, and he was in this country until 2017, when he unsuccessfully defended or lost an appeal against his deportation. But then upon deportation to the DRC, he was detained in solitary confinement in what is a notorious prison in Kinshasa, and interrogated by the security services, and was deprived of essential HIV medication there. He managed to come back to the United Kingdom and wanted to make another claim for asylum, this time on the basis of what had actually happened to him. Now, the Secretary of State, before he turned up, the Secretary of State knew about his HIV status because of his previous asylum determinations, but also because his solicitors put them squarely on notice that this was that he had HIV, that he required antiretroviral medication, and that was made clear through representations and otherwise. Nevertheless, he turned up for his screening interview and was detained, and he was detained in circumstances where he drew to the Secretary of State's attention in person that he did not have his antiretroviral medication and that he required it. Now, the detention gatekeeper told them, told the officers in the detention center, in the short-term holding facility, you can't detain him unless he has his antiretroviral medication. And instead of deciding that they better not detain him, they decided to do whatever they possibly could to keep him in detention. And so, I mean, what this kind of caper that they went on afterwards is it would be funny if it wasn't so shocking. Firstly, they took him to Boots to ask to see if they could get him some antiretroviral medication. They obviously said no. Then they took him to A&E and told him and asked if they could give him any antiretroviral medication. They obviously also said no. In that 48-hour period, he spent about a day and a half lying on the floor of the waiting room of this short-term holding facility, taking the packets of crisps and orange juice that were giving as some sort of hospitality welcome to new inductees, waiting to be for the next trip. And in that time, all because they wanted to detain him. Now, eventually they get authorization from his consultant for his medication. That happens 48 hours later. And because of the stigma that he still felt and feels about his medication, he didn't wish to take that medication in front of his cellmate, and so waited another 8 or 10 hours before he could face taking that medication in private in the nurse's office. Now, we all know, and I'm not going to go into, and I'm sure everyone on this conference call knows how serious it is to miss your medication, and that regularity is critical, and because HIV can rebound and can reduce the effectiveness if it's not taken regularly. Now, going back to the point about why collaboration and working closely with NGOs and so on is so important, it's been critical in this case in producing compelling evidence, because we've got a joint letter from the Terence Higgins Trust, the National AIDS Trust, the British HIV Association, all who at a very high level, so you've got the heads of policy there, the directors of policy and so on, put together a joint letter which spelt out exactly that which the Secretary of State ought to have known but didn't know, as to why the detention centre didn't meet the requirements for, didn't meet the standards as set out in the clinical guidelines, why 95% adherence to treatment is required in order to be effective, and why the gap in treatment provision was especially serious in my client's case because of his already advanced HIV infection and his low CD4 count, and made clear that every detention centre has to have in place a clinical protocol for the management of newly arrived detainees, which is completely absent as things stand. And so what we are trying to achieve in this litigation, and I'm sorry, you'll have to indulge me talking about the law for a little bit, but you may expect me to say something about it, is that the Secretary of State bears what's called a systems duty under the Articles 2 and Article 3 of the European Convention to put in place appropriate legislative or an administrative framework for the effective prevention of risks to health and the well-being of detainees. In this obviously context, we're talking about someone who's living with HIV, and that the Secretary of State owed a protection duty to my client and to any detainee entering the estate, owing to her own obligations under Article 2 and 3 to take reasonable measures. So we're making 3 points about the current state of affairs. The first is that the Secretary of State knew and ought to have known that my client had HIV, and without daily antiretroviral medication, he was at real and immediate risk of serious harm. And she failed to make any such arrangements as she was required to, and thereby breached her Article 3 protection duty. The second point is that the Secretary of State's breach of a protection duty is symptomatic of a breach of the Article 3 system duty in relation to all detainees with HIV, and she's failed to put in place an effective framework for the protection of immigration detainees with HIV, and that can lead to serious harm. And that finally, the absence of a policy framework for the protection of detainees with HIV is a material error that meant that his detention itself was unlawful, and the detention of others with HIV was potentially unlawful. So that's the summary of that case. That's what we're trying to achieve. I hope I've made clear that what we're trying to achieve could not happen and cannot happen without the close collaboration of those who remain engaged in this field. And I've tried to keep it as short as I can, not least because I've got my eye on the time, and I'm most of all interested in any contributions and questions anyone has to ask. So that's all I propose to say for now.
Raza, thank you very much, and giving us another salutary view of contemporary challenges that we face. Wes talked about dark times, and it doesn't seem like there's much light going on at the moment when you think about the treatment of that particular person. So we are now going to have our last contribution from Leila Zadeh. I don't know if I can see Leila at the moment. She seems to have disappeared.
She said she had to go, Steph, at 6:30.
Ah, okay. Well, I didn't realize that. Well, that's a real shame. What we can say about Leila's work, and this may be something that if you're not already involved in it, to think about getting involved. Leila is the executive director of the Lesbian and Gay Immigration Group, which is the group that Wesley talked about having set up many years ago, still going strong. And its role is particularly important in maintaining the campaigning and supporting activities for the rights of LGBTQI people, alongside others who also have HIV. And so if you are interested at all in carrying on from some of the issues that we've talked about today and getting involved in that group, then that will be a real bonus both for them and to carrying on all of the inspirational work that we've heard that has been taking place, both in terms of campaigns as well as in courts and in representing individuals. I think in terms of contributions from the audience, we're in your hands. We haven't got any specific questions in the Q&A at all.
There's one in the chat, Steph.
Okay, Sorry.
Zehrah.
To Zehrah.
About Papashvili. Yes, interesting question.
Well, let me find that. Francis, can you just read that out?
Okay. In Papashvili, the court said that if doubts persist about the impact of removal, the expelling state must obtain individual and sufficient assurances from the receiving state as a precondition for removal that appropriate treatment will be available and accessible. My question, therefore, is, 1, any evidence that the UK is making use of what looks like a potentially large loophole to get around Article 3 in medical expulsion cases? And 2, what would constitute individual and sufficient assurances?
Yeah, I do think that's a really good question. I think the first thing to say is that in terms of doubts persisting, as the Supreme Court made clear in AM, it is about serious doubts on the impact of removal. And so in terms of this sort of these procedural requirements actually kicking in, I think in reality, it's only going to come into play where there are very serious doubts or contentions around the availability of that treatment and the accessibility of it in the receiving state. And so in relation to putting your case strongly kind of initially, it is really about that expert evidence that I was talking about, and making sure that there are no serious doubts in the first place. And I think if that process is then triggered, in terms of what constitutes individual and sufficient assurances, I think it really is probably fairly untested territory at the moment in terms of this application. But I would say that it will have to be something that's fairly concrete in terms of the availability of treatment in the returning country. And I think that we should interpret it that way in order to make sure that those obligations are complied with. And so I think that actually it is probably quite helpful if you are at a point where that is being triggered, for it to be quite a robust assessment that's needed before removal can be considered lawful and not in breach of Article 3. So, yeah, I mean, I don't know if anyone else has anything to add to that question, but that's sort of my interpretation of it.
I think that part of the answer is in the Supreme Court's judgment itself in AM, which is, I mean, the thrust of that case is that you've got to, it's for, as Zehrah says, it's for the claimant to, or the applicant to demonstrate a strong prima facie case with all the evidence, and that's why the evidence gathering is important. And then you go to the second stage, which is for the Secretary of State to decide whether that evidence reaches that threshold, and then we'll interrogate the evidence and make inquiries thereafter. But it's if the initial prima facie case is not answered, then that's the end of it. The threshold is deemed to be met. So you've got to read AM Zimbabwe, I think, rather than go to Papashvili. AM Zimbabwe is the authoritative domestic interpretation of what Papashvili means in the UK, at least.
Yeah. I mean, certainly, if that becomes something that the government develops as an answer to AM Zimbabwe of looking to get assurances from governments, we know from the context of assurances against torture that they are not going to be worth the paper that they're written on. And it took a decade to be able to demonstrate that the assurances that the Labour government agreed with Algeria, Jordan and Libya were not a proper protection and a guarantee of what would actually happen on the ground. And so that really is something that we have to guard against becoming a mechanism for cutting down the advancement that's been made by AM Zimbabwe. We have another question. Maybe this is something that Wes might want to answer. So we have a question, which is, given Terence Higgins Trust's role intervening in N, etc., It seems that there has been an inclusive approach to HIV/AIDS advocacy. Is that correct? Or has there ever been a narrative of the good gay to appeal to the Daily Mail crowd? You just have to unmute yourself, Wesley.
I'm unmuted.
Yeah, you are.
I'm not quite sure that I understand the question.
Yeah, I think that it's saying, yeah, is that, I suppose the question relates to some of what you were talking about how the success of work that was done is inclusive and it includes everybody.
Well, there was a bit of a fly in the ointment in around 2000. Terence Higgins Trust found it a bit too much to have a pack of lawyers wanting to do things and disbanded it. And so now I think decisions about litigation are taken by whatever staff members they have. For back in the 90s, they had a legal team of 3 or 4 staff and 25 or 30 really excellent lawyers from all different fields. And so there was a more aggressive pattern developing of litigation. I think if anything, it's probably decreasing a bit now, but I'm not really up to date with what they're doing today. But they found too many lawyers in the House was disturbing.
Yeah. Probably all agree with that. So I think looking at there's no other questions and we've already overrun in terms of time, but I would like to just thank every speaker who's made their valuable contribution and given us an insight and certainly an inspiration, both in terms of how to challenge and to fight injustice in dark times. We need that perhaps now to be revitalized more than at any other time in recent experience. We seem to be back into a sort of 1980s, perhaps worse, potential discourse coming up, particularly in respect of the protection of the rights of asylum seekers and migrants, and the inspiration of working collectively, inclusively within our communities and across them is the one that I hope that we can take away from this meeting, and as a proper reflection of what was intended to be the benefit, the role of LGBT History Month. Obviously, everybody has to say when one is talking about months, it's not just a month, it's how we integrate and pursue our work across the board on every day of the year. And I hope that what you've heard today helps you to continue to do that in the way that we do with as much success as possible to answer that question put by the case in N. Is it any less inhumane to deport somebody to circumstances where they would face imminent death as opposed to losing what would otherwise have been decades of healthy life? I think any person applying any notion of humanity has to answer that question. Of course, it's equally as inhumane, in fact, possibly more so. And it's perhaps one of the most important, profound areas of work that comes across an immigration lawyer's area, to be working in a case like that, where you can save the decades of healthy life for an individual. And it does ask you to ask that question: what price do we put on human life? Certainly, if it was £10,000, when they're talking to, it's less now because the drugs are less. £7,000 a year it costs to provide the antiretroviral drugs that ensure a healthy and life for a person with HIV now. And that really can't be too big a price to pay for honouring, even in contemporary times, what was intended to be the fundamental basic protections from the European Convention of Human Rights, of which Article 3 is one of the key protections. So with that, I think we just double check. We have 3 new messages. We won't be able to answer any questions. If there are any pressing questions, we'll answer those in writing. Thank you very much for your presence and your contributions.